Payers of previous bail. The payers of previous bail.
Because I'm already on bail, madam.
It's okay. I saw that. I saw that. What is the matter?
Bail application under 439.
439. Okay.
Sure.
Yes, item 1. This NDPS will call for the case diary. Give the date. Court master will give a date. Just bear with us for some time. Court master will give a date consulting the APP.
1611.
Huh?
1611.
1611. Okay. If you want any adjustments, please tell us because we are depending on the APP for the dates. Correct? Okay. What is the matter? Bail application. Okay. Okay, permitted. Yes, item 2.
Item 2.
I take your loss. There are 2 loss of her. First one was filed by us, second one was filed by here my neighbor. It is a quarrel for cutting a bamboo mine. My father was severely injured, has been taken into custody, and he is last 65 days in the state. That's a different case. Now, these 2 sons, first one is against the president of his local municipality and a BJP unit secretary. The other
Where is the FIR?
FIR is page melody 18. Sorry, page 17 melody.
But there is an allegation of the victim being raped.
Rape?
I don't know. That is what the FIR is.
Oh, this is
376D.
This case by the CT call.
376D.
And notice to the informant.
Notice to informant. 376D. This I see discuss.
1411.
1411. Okay. Mr. RJ Burma. AAPP. Case diary. Okay.
But notice to the informant by the
Notice also. Notice. Yes, item 3. This is also. But you have not implemented the victim or informant, whoever.
Informant is mother.
No, whoever, she's a minor, she can't be represented. But you'll have to get it corrected. Okay. We'll list it on the reopening day, on 6th. By the time you correct it, the counsel for the petitioner is permitted to implead the informant as respond number 2, which shall be done in the concerned section. 7th. Okay. List on 7/11/2023. We'll send it. We'll try to send it today, but today since there is a shortage of staff, we'll try to send it today or today only. Mr. Pathak, Mr. Barba, instead of fixing a date, can we issue a notice in the meanwhile, pending correction of the cost title? We'll call for the case. It saves 1 day.
So let him take a step to the
Huh?
Let him take a step to the
Okay.
Okay, I am allowed. I may
This will not do because it has to go in the section. It has to be corrected. Otherwise it will not show in the cost title. Pending correction of the cost title. Let the case diary be called for. Next para. Pending implementing of the informant as respond number 2. Issue notice on the respond number 2, returnable on so and so. The next paragraph, the learned counsel for the petitioner shall take steps in course of the day for service of notice on respondent number 2. Post of the office after receipt of the notice shall hand it over to the learned to Mr. R.J. Barwal and APP for onward transmission to the informant through the jurisdictional police station. Post of the learned counsel for the petitioner shall also provide a soft copy of the petition to the learned APP based on so and so. Give a date.
16/11.
Item 4.
Yes.
This is a bail application of 39 of the Your Lordship, I was
This
FIR is at page 13, Your Lordship. I was arrested in connection with the cyber police station case number.
just wrong.
Yes, sir.
When were you arrested?
59,023, Your Lordship.
59.
Yes, Your Lordship.
You can release him on bail. There's more than a month.
Yes.
There is 49 days. One good, he said, mother 4 days.
Your Lordship,
Because these people, they are merely working as
yes,
in the call center.
What is the actual allegation? So her name has not been mentioned in the FIR. Only matter of the forwarding report, but there are some allegations against her.
No, Mr. Barwal, please, don't, what do you call, don't interact when I'm speaking in your favor, correct? Please know the art of advocacy. Mr. Barwa, you see, if there are call centers operating, fake call centers, if they are the owners, then I can understand. But there are so many young people who are lured in this, what you call call centers, fake call centers. If they are merely workers, then their culpability will be limited. I don't have a job. Somebody offers me a job, I go there.
Whether look at they are working in connivance with the main accused person.
Huh?
Whether they are working in connivance with the main accused person. or not.
No. You see, let us say, let me give a horrible example. Let me take you as an example. Correct. Now you are under since you are under the state authorities feel that in one particular case you must object. Correct. There is a request from the concerned officials that in one particular case you should object. Now, can it be alleged that the officer of the court is in connivance with the officials to object? You see, it's a decision. What you call these boys and girls, they are given a allotted of work to do some work, because we also receive this call centers phones always. Correct. So they are assigned duty and they call us. At times when they say that I am from insurance company, I disconnect. If they say something good, I listen to them for 2 minutes and then disconnect. So my question is that whether there is a culpability of these people in giving a call, because if more than a month, if you can show that this call center called this man, he was swindled and the money went to his own or her own pocket, then I can understand. From the forwarding doesn't appear.
For the forwarding report also as a whole, so there are some main accused persons. And in the forwarding report, there are 52 persons. Her name has been included in the serial number 50.
Mm.
So there is out the versus on the immediately of seal from.
Okay, this thing on the reopening day will be difficult. We are making it 7th. Let the case diary be produced on 7/11/2023. First of all, it is made clear that if the case diary is required for some, before some other court, comma, the IO shall produce his instructions showing the culpability of the present petitioner in connection with the offense. Which may be sent through the learned AVP. Case diary or scan copy on 7/11/2023. So on 7/11, if the case diary is required by some other court, then culpability of these people. Huh? Okay, we are adjourning the matter.
But there are two other items, item number 11 and 16.
11 and
11 and 16.
16, you are there?
Arising out of the same PSK. So may
Okay.
I get them to show the mathematics out of it?
Anybody is there for 11 and 16?
11 and 16.
We are fixing the same day. Arising out of the same police station. This is IT Act. IT Act matter. On 7th.
Much of it.
Okay, 7/11. We are fixing for case diary.
Item 5.
Let's call for the case diary. Okay. Oh, LCR, okay. Call for the scan copy of the relevant pages of the case record from the Court of Learned Additional Sessions, Judge number 1, Kamrup Metro, Guwahati. Records of, what is the case number? NDPS case number 211 of 2022. Under section 20, C of the 29, page 1. Number 3. Okay, number 3. Additional sessions are number 3, Kamrup, Guwahati. Okay. I'm not bothering with the up-to-date status report because you see what happens is that these judicial officers, I was informed that they have to spend time writing the status. Correct. So I'm avoiding that. When they are sending us case diary, we'll hand it out.
Why I'm saying that it is first PW1, he was examined on 20 May 2023. What happened after this?
No, we are asking for the case records, relevant pages of the case records, including statement of witnesses. Because these judicial officers, they have to spend time writing the report to the High Court. That's why. Item 6. This is item 6, okay. Huh?
NDPS method, that's item 6.
Okay.
Different case.
Different case. This NDPS case number 82.
Okay, here, little different case. Huh? NDPS case number 82 of 2023 from the Court of Additional Sessions Judge number 1, Kamrup Metro, Guwahati. Okay.
Item 6.
Make it 8/11.
Item 6, 8/11.
Hello.
Item 7.
This is again NDPS. We call for the case. Huh? Pardon me? 20. 61 days today. What is the quantity? Can you get us information that the charge sheet has been submitted, Mr. Gogoi?
I will.
We'll take it up at 2 o'clock. 2 o'clock or earlier when we get information, please be here, be in contact with the Lebanon APP. 7, 8,
Item 8,
oh, this is that ATM.
FIR was on 10 August and the original case is version 15. The same.
No, we'll still call for the case diary. This is that ATM scan. Okay, case diary,
8 versus and from Doboka. Another clear number is 3980.
on 8th. Achha, on 8/11/2023, along with BA
3980.
3980 of 2023. Because the case diary is already coming from the same, so you don't need to pass a fresh order. But, just write case diary on so and so. Okay,
9,
9. I think Mr. Gogoi here, he'll be entitled to bail.
Oh, my lord, here the POXO section is there, my lord.
No, that POXO will not apply. At the date of the marriage, girl was a major. POXO will not apply.
Police edit.
No, that may be there, but there's a, what you call this, this birth certificate is there. If birth certificate is there showing the girl as adult, POXO can't be added. In fact, now you are aware, if somebody is falsely implicated in POXO,
Yep.
the informant itself will be in trouble. Correct. Here the date of birth is 2/1/2005. 2/1/2005. Date of marriage, the petitioner says, as per the certificate, is 12/1/2005. Last annexure. So she'll be an adult. No, the 2/1, no. You made a mistake, I think. Uh, 5th October 23. 5th October 23 means because Mr. Ali, what the prosecution has not done, you have done it. Now you have made this girl a minor. She was married on the day she was born.
No, my lord, this is certificate was issued, my lord.
No.
Mary's on the microphone.
No, look at the index.
I'm sorry.
Look at the index. Now you have made her a minor.
I'm sorry.
Certificate she is a major.
Before my pa.
No, but I must believe in the officer of the court. I can't say I don't believe Mr. Ali. So, Mr. Ali, what to do? Should I believe you or not?
Not she.
Should I believe you or not? Okay, we are granting bail, Mr. Gogoi. I don't lose an opportunity to smile. Mr. R. Ali, counsel for the petitioner, and Mr. B.B. Goel and APP for the state. Next, the petitioner was arrested on 3/10/2023 in connection with Howley PS case number 163 of 2023 under section 120 capital B IPC read with section 9/10 of the Prohibition of Child Marriage Act 2006 read with section 6 of POXO Act 2012 is seeking regular bail under section 438 CRPC. Next para. The learned APP has opposed the prayer for bail on the ground that the petitioner is accused of offense under section of committing offense under section 6 of the POXO Act, and therefore before grant of bail, a notice is mandatorily required to be sent to the informant of the victim. So he also submits that prayer for bail should not be granted without giving appropriate opportunity to to him to oppose the bail application by calling for the case diary. Next para. It is observed from Annexure 3 to this bail application that as per the birth certificate issued by the Department of Health Services and issued by the medical officer IC. What is this? Sidley PSC. Sidley PSC, the alleged victim girl was born on 2/1/2005. Full stop. As per the certificate of marriage issued by the Marriage and Divorces Registrar, Bilasipara, the Office of the Muslim Marriage and Divorces Registrar, Bilasipara, dated 5/10/2023, the marriage of the alleged victim girl and the petitioner was solemnized on 12/1/2023. To stop. Therefore, on the date of marriage, the victim girl was a major. Having crossed the age of 18 years. Full stop. Under such circumstances, the court does not find any requirement to issue notice to the respondent, but to the informant. Or to await the production of case diary. So considering that the petitioner, that the victim girl was a major and the marriage was solemnized between the petitioner and the victim girl, and considering that the petitioner has been arrested on 3/10/2023, the court is inclined to release the petitioner, namely so and so, on bail, on furnishing a bail bond of ₹40,000 with one surety of like amount to the satisfaction of the Special Judge POCSO, which place? Bopeta. Next one. The release of the petitioner on bail shall not preclude the IO of the case to examine the correctness and veracity of the birth certificate and marriage certificate, which are annexed to this application as Annexure 3 and 2 and 3, 3 and 4 respectively. So, application stands allowed. You may send it to the police, Mr. Gogoi, for investigation. If these are fake, law takes its own turn.
Item 10.
Yes, after some time. Okay. Item 12. Transfer application. What is the ground?
Appearing in the court of Wilson Mission First Class well of one bibliography standing. That will also be until 18 and 19.
Okay. Had Mr. A. Ahmed, counsel for the petitioner. Next, the petitioner, who is the estranged wife of the respondent, is seeking transfer of matrimonial proceedings of TS within bracket M, number 56 of 2023, from the Court of Learned Munsif, Bongaigaon, to the no, civil suit can't go there. Civil suit can't be transferred to criminal court. to an appropriate court at Dhubri. Stop. It is projected that the respondent is already attending the proceedings of which page? Proceedings of CR within bracket DV number 230 of 2023 before the Court of Judicial Magistrate, first class Dhubri. First stop. Issue notice written by the insurance law. Petitioner shall take steps in course of the day for service of notice on the respondent by registered post with AD. First stop. Till the next returnable date. The further proceedings of TS within bracket M. No, but TSM can't proceed in Munsif. We are unable to accept it. A divorce suit can't be entertained by a Munsif.
No, it is for restitution of convenience. Restitution of convenience.
No, that also can't be taken up by Munsif. District judge is the competent authority. You'll have to first. No, because we can't take cognizance of this. If it is not in an appropriate court, you move an application there. Why should we transfer it to an appropriate court having jurisdiction? From a court having no jurisdiction, why would the court case be transferred to a court having jurisdiction? We can't do it. No, but you take your own steps. You see, a court having no jurisdiction, just tell us the correctness of the order. A court which is having no jurisdiction is entertaining a matter. From there, we will transfer it and give it to the court having jurisdiction. Can that be done under 24? No, I understand, but you see, take a situation in a criminal side. POCSO case is being taken up by judicial magistrate first class. And you want us to invoke 482 and transfer it from a court having no jurisdiction to a court having jurisdiction. Is that permissible? I can't cure jurisdiction. Jurisdictional error can't be corrected in 24. You close it, you take your own steps. Because this is something I find it very difficult. Unless you can convince me. Would it be appropriate for the court to transfer a case from a court having no jurisdiction to a court having jurisdiction? Take a call. Court can't assume jurisdiction. So you have to first take a call, get it to the appropriate court and then move an application. I don't know. This is something I have not come across. Especially to transfer a matter to a court having jurisdiction. I don't know. Yes, can I have the assistance of the bar? What do you feel? Mr. Kamar or Mr. Buragoy, what do you think? I'm just taking a assistance because this is something I have to in the course of learning.
Actually, when the court is without jurisdiction, you cannot pass anything further altogether. As I was hearing it, how can a restitution petition can be filed into the mixing matter?
No, I am not on that. The second part is my question.
Yes.
Whether it would be appropriate for the court to exercise jurisdiction under section 24 and transfer a proceeding from a court having no jurisdiction to a court having jurisdiction.
Somewhat tricky.
No, because you see, Mr. Kamar, why I'm asking is, I gave you an example of criminal side also. Now you see what is happening. If a court is having no jurisdiction, it can't try a matter, and the decree would be a nullity. So therefore, what the court will be now the court will be doing is to get the case from a court having no jurisdiction and give it to one having jurisdiction. So it will be cure of the jurisdiction issue. This is something I don't know. That's why I'm asking you.
My friend's wife is having impact on the everybody is having problems. Petition is the wife.
Is the wife?
So she is having problems going there and finding it.
No, I understand.
Otherwise, kind of, if the attendance can be disposed of with the right hand, then kind of it can be disposed of, but no jurisdiction.
But why should I say that? He's there to guide the, it's not the court's business to advise.
No, no, no. I'm not saying it.
So that is my difficulty.
Then still will save the situation.
No, I understand. That's why my question, because this is something I have not come across. That's why I wanted.
Our thing.
Thank you, but Mr. Kumar. And fix it with the application. Based on 8/11/2023, as paid for by the council of the petition. But fourth year, is it open? No.
Still also observe that the personal.
Hmm?
Personal appearance of the petitioner is that's what.
No, we'll say that, we won't say that, so at this juncture, the learned counsel for the petitioner further submits that, that he may be granted leave to, leave for an exemption from personal appearance on the next date fixed. In this regard, the court does not offer any comment because personal appearance in a civil suit is again a debatable question, because in a civil proceedings, a party can appear through the learned counsel or through an agent. So therefore, the court leaves the matter open to the petitioner to take a call on the issue of personal appearance. I'm not making any comment because you see, ideally in a civil suit, you don't have to be personally present. And here only a summons is issued. I don't know in summons whether there can be a summons for a personal appearance in a suit on the first date. I don't know. Huh? Yes, we're sending you back. 8/11 we are fixing.
Time being item 7.
Hold on. Here also we receive instructions on charges submitted.
Charges submitted. Her name says ZR. Her name says ZR, then counsel for the petitioner. So, upon instructions, Mr. D.V. Govil and APP submits that that a charge sheet has been submitted against the petitioner in connection with Manikpur PS case number 157 of 2023. However, he does not have the necessary particulars. Therefore, this bail application stands closed, with liberty to the petitioner to move the jurisdictional court for bail. Jurisdiction oblique. This will be NDPS, no? Jurisdictional court. Okay.
Item 13.
Transfer of suit matter, section 24.
Huh?
I think the transfer of that matter, I think section 24 of the CPC provides that it can be done from an incompetent court also. That is what I found in live law. I don't know.
24. CPC.
Section 24,
No. You see, that's on a prayer made by somebody.
prayer made by the agreed
But
party.
the court in exercise of 24 will transferring proceedings from court having no jurisdiction, because then I'll be prejudicing a party.
Got some decision.
No, that is okay. If it is no jurisdiction, then district judge can transfer. Because if it has been wrongly registered, let us say, for example, uh, say a copyright case, somebody files a suit in the Munsif, and therefore instead of having the plaint returned,
They transfer it.
they transfer it to the competent court.
Court itself, they can do it, but by the high court, by the court itself, they can do it.
Because that is the administrative power vested on the district judge. But now here what we'll be doing is that we'll be calling a record from the court having no jurisdiction and giving it to a court having jurisdiction. So that will prejudice one of the parties who may get advantage of a court proceeding without a jurisdiction, because the decree will be nullity.
That is the knowledge.
So ideally, a good lawyer will permit the proceedings to go on.
Yes.
Take a plea of section 21.
I
Correct.
have no result.
Take a plea of section 21, allow the proceedings to go up. And then they'll say that I took an objection, but the court rejected it. I said that it has no jurisdiction, so therefore decree becomes a nullity. That's my view. I don't know whether it is right or wrong, but that is the view. Since this is a point which I have not done any research, so therefore I can't say with conviction that this is the correct view. No, but still, thank you for your comment. At least we must be in the process of learning every day. Yes, Mr. Barbia.
Before coming to the tax of FIR level, the tax is that level.
No, this is 498A. 41 notice has been sent or not? Ask the IO.
Has not been served, but I had.
No. Question of serving and issuing is two different things. Let the 41A notice. We'll take it up at 2 o'clock. Let her get information.
That I'll get the instruction.
Because if there is a 41A notice, then you will not be entitled to bail. You'll have to go there. After the new recent judgments, after what do you call Arnesh Kumar and latest 3-judge bench,
You know,
police can't arrest.
there will be contact.
It will be contempt. So get an information either at 2 o'clock or earlier, whenever you can get.
I'll get.
Item 14.
We'll have to call for the case diary here.
Can you see that with the register of what agreement is there, also the
No.
authorization letter was there. And thereafter the demarcation has been filed and that has been allowed in my favor. Everything is there. Only thing is that I have to take now, also go to bring the vehicle from the police station. Also, that is why I need the protection. It's a formal protection.
Everything is happening is wrong.
But
Correct.
Jima has been granted, Lordship, but.
No, that is okay. What is happening is wrong.
One, Lordship, you can see, one, the authorization letter is there, page 16.
That's what I am
There is
saying.
1 month back, Lordship, it is on 36 and the FIR is on 37. Lordship.
No, that is
Only
okay.
Limited protection to take the vehicle, Lordship. Otherwise, city council, Lordship, if something is there, definitely.
No, I'll tell you why. The vehicle, as per the registration certificate, is not authorized to carry cattle.
No, that is, he will be responsible, Lordship, the driver, Lordship. It will specifically mention. Lordship, that on page 70.
Motor Vehicles Act. That's it. Motor Vehicles Act. Did you?
Yeah, Lordship, I'm not going to name that back, Lordship. The only thing is.
It's okay, but I'm trying to show you that.
It was given on monthly hire basis, Lordship, that he was responsible for carrying the goods, Lordship. That is none of my business, Lordship. I get monthly rent, Lordship.
Section 2, subsection 30. Owner. Thirty or 36?
Section 2.
2, subsection 30, I think. If not 30, it will be 36.
36.
Two,
Subsection 36.
30 or 36, owner.
Owner. Yes, owner
Hmm.
means a person in whose name a motor vehicle stands registered, and where such person is a minor, the guardian of the said such minor, and in relation to a motor vehicle which is subject of a hire purchase agreement or an agreement of lease or an agreement of habitation, the person in possession of the vehicle under that agreement.
Correct. So that's why I'm saying it is wrong. The court could not have given Jima to the person who is not the owner. He is not the owner now.
He is not here. Oh, the vehicle is on application.
No. Vehicle is on a hire, on an agreement for hire.
Hire.
So under the definition of 230, now Mr. Muni is not the owner.
Right, but the order reflects my, that is going on, but nobody.
In fact, there are judgments, it cannot be given to owner only. It may be given to the person who's managing the vehicle.
No, but you see, the court can't give Jima without issuing notice to the owner. Third party can't be given custody of a property. So that's why I said it was wrong.
They have opted the instruction from the IO law then the instruction of the IO law is not in the fire visual that is why the
Yes,
Driver fled away, in fact, when it was seized. He fled away, taking the advantage of darkness, that is not a picture. Let the case diary come because it's difficult and
you give an interim bill then.
that's it.
You give an interim bill if he has given the Jima.
And 379 is also there, Capital Preservation Act is there, how they are kept, how the animals were brought.
Because the car is not authorized to carry
Authorized to carry those.
under the Assam. No, there's a amendment in the act, main act.
But it is that person of the driver who is trying the vehicle. I think only the register owner of it, that is why I was in charge by the police office. And as per the Jima of the police also did not create any objection regarding the register owner. So the vehicle was allowed on Jima. Normally police say that they have not placed out the register owner document. Normally what is in the
Police will not what you call read this, to subsection 30.
Vicarious liability thing will also come.
But at present, I will go and here we would have in connection with this case.
Okay. Heard Ms. S. Munir, counsel for the petitioner, and Ms. S. Jahan Lani, APP for the state. Next para, the petition, the apprehending arrest in connection with Agomani PS case page 1, PRS bill 438. Next para. The case diary be produced on the case diary be produced on the next date of listing. Next para. The learned counsel for the petitioner has prayed for the interim bail on the ground that he is the registered owner of the vehicle and that the driver of the vehicle was carrying cattle illegally in his truck, had fled away when the vehicle was intercepted. It submits that the learned trial court, sorry, which court? The court of learned.
You can mention first.
The Judicial Magistrate First Class Zubi, by an order dated 8/9/2023, passed in GR number 1248 of 2023, had allowed Jima of the vehicle to the petitioner on execution of indemnity bond of rupees 10 lakh with conditions attached thereto. So it is submitted that the petitioner apprehensions that he may be arrested when he approaches the Agomani police station for taking the vehicle in his Jima. First of the prayer for interim bail is opposed by the London APP. Next prayer. In view of the hearing before referred order dated 8/9/2023, passed by the London Judicial Magistrate First Class Dhubri in GR number 1248 of 2023. The court is inclined to grant interim years bail to the petitioner, namely so and so. 40,000 with one surety of like amount. With the subsection of the arresting authority. Conditions are there. Along with conditions, it will be there that if he fails to appear within 7 days, the interim bail will be lapsed on the 8th day. Based on so and so. When?
14th of November or
14th November.
20th of November?
20. Okay.
Not over, not over.
15.
Item 15.
What of your verification number? FIR
Where is the FIR?
There are three people on all of three are FIR name is.
He was stabbed. We'll call for the case diary then.
Number one in the victim matter.
But the allegation of stabbing is there in the chest. No, but still, no. Not when you stab someone for under the chest.
Which after
No.
CD with medical report.
CD with medical report. No, but case of stabbing on the chest, there is something is.
Today is second, so 9th of October? 9th of November. yes.
Case diary on nonsense. Item 17. Ms. Jahan,
Gotcha.
can you grant interim bail to number 1 who is 80 years and to this female's respond number 7 to 10? There is a scuffle. Both sides lodged in FIR.
That's covered.
Petitioner number 1 is 80 years.
26 there, petitioner number 1 is
80 years.
80 years. 40, 25, 30.
And these others are females.
But let's see what the allegation against one specifically, Shaukat Ali.
But
They
80 years,
put some-
whatever allegation may be there, but 80 years.
149 is there. 143 is there. Consider the 80 years.
It's highly improbable for him to go with this bamboo stick, dao lathi.
Regulated daughter-in-law and tried to kill all this. And there was an earlier occurrence also, for which they went.
14 petitioner initial file contained before page number 3.
No, doesn't help. Because if you think that somebody has occupied your land, you will go to a civil court.
Case is pending. Civil case is pending. Looking in FIR, in my FIR, case number 21.
Page 21.
On to go.
Page 21. Huh? Oh, that is page 22 here. Yes.
শওকত আলীৰ নামত থকা মাটি খান মহম্মদ আলী আছাউদ্দিন আলীয়ে শওকত আলী জীৱিত থকা স্বত্বেও মৃত সজাই সিহঁতৰ নামত মাটিখিনি নামজাৰি কৰি লয়। ইতিমধ্যে মহামান্য আদালতত কেছ চলি আছে। আজি এইটোতে শওকত আলী ৰুবুল আলী
This is not a civil case. Nothing suggests there is a civil suit. And it is very vague. A case is going on in an honorable court. Which honorable court? This is also an honorable court. In my court, there is no such case pending.
Is there any comment in the meantime? One case,
Yes. Huh?
others are all sons of Safdar Ali also.
If anything out of it.
We grant protection to ladies also.
Sons of
Grant protection to ladies also.
ladies,
7 to 10. Mr. A. Sharma, counsel for the petitioners, Ms. S. Jahan Lal, APP for the state, apprehending arrest in connection with Sipajar PS case number so and so, page 1 of this prayer for PRS bill under section 438 CRPC. Next one. Let the case diary be produced from the next returnable date. Case diary or scanned copy thereof be produced from the next returnable date. The learned counsel for the petitioners has paid for interim bail, which is opposed by the learned APP on the ground that the petitioners had formed a group and attacked the informant with weapons like lathi rod, dao, etc. Next paragraph. Considering the projection that the petitioner number 1 is aged 80 years, further considering that the respondent the petitioner numbers 7 to 10 are females, the court is inclined to grant interim PRS bail to petitioner number 1, namely so and so, and petitioner numbers 7 to 10, namely so and so, interim PRS bail by providing that in the event of their arrest in connection with the aforementioned case, they shall be released on interim bail on furnishing bail bond of rupees 25,000 each with one surety of like amount to the satisfaction of the arresting officer. Bail is granted on the following conditions. One of the conditions will be that they will all appear before the IO within 7 days, following which the interim protection shall lapse on the 8th day. Case diary on
16th November. 16th November.
16 November. Okay.
Item 18.
They have, of course, the cases raised under 376. But the issue is that matter is a logical impact has a their original of the FIR, which is the FIR of minority of all is not that they have been projected.
Something
Yes, madam, something
She-
family background is there.
grant an interim bail.
And he happens to be the brother-in-law of the.
We'll grant an interim bail. We'll grant an interim. Heard Mr. Z. Kamar, counsel for the senior counsel, assisted by Mr. B. Talukdar, counsel for the petitioner, and Mr. K. Parashar and the AVP for the state. Next paragraph. The petitioner is apprehending arrest in connection with Agomoni PS, page 1, is paying for PRS bail under section 458 CRPC. That the case diary be produced on the next date of listing. Next para. The learned senior counsel for the petitioner has paid for interim bail, which is opposed by the learned AVP on the ground that the FIR alleges sexual assault on the victim. Next para. On a perusal of the contents of the FIR dated 19/8/2023, it appears that the informant and the petitioner had been in some sort of relationship for quite some time. In this circumstance, the court is inclined to grant interim PRS bail the petitioner, namely so and so, providing that in the event of his arrest in connection with Agamani PS case so and so will be released on interim bail. Same 40,000 with one surety of life amount, same conditions.
I go and pay.
I am not saying that. I'm just saying that within 7 days, within 7 days, if you don't appear, then the interim protection will lapse. For case diary on 20/11/2023.
Item 19.
19. This is 302. I'll call for the case diary. Case diary on which date? Case diary along with postmortem report on. Postmortem will not be available by then. Huh? Postmortem of the in inquest report. Huh? Postmortem of the or inquest report. Just add one more thing. It's case diary or scan copy thereof, including postmortem report and inquest report, if available. 14/11/2023. Okay. Wherever we are calling for the case diary, just say case diary or scan copy thereof. Item 20. Page.
Petitioner is not named in the FIR, but accused number 1, he is the brother of the he was arrested all the 3 first FIR.
Oh, this is ATM card. No.
Yeah, everything there. The FIR and accused person took the account of the informant to receive data from other companies. And thereafter they received and they also gave some portion of amount to the
No,
informant.
but still not without case diary.
Yeah, last time see that FIR accused persons were already granted bail after 2025 days. Their order also I have done it. And only in that section 420. In individual also produce the FIR, evidence of 420 is not there. Because he was.
No, but not a case of what you call pre-arrest bail. Not a case of pre-arrest bail.
In the name of this person also money came to that account.
No, I don't know, just something is not striking right. Therefore, that the case diary or scan copy thereof be produced on the next date of listing. First, it is also provided that in the event the case diary is required by any other court, the IO shall send the status of investigation to the learned APP along with the nature of culpability of the petitioner.
1411.
Huh? 14/11.
Can it be based on time?
Make it because I am not granting an interim bail.
10 minutes.
10th, okay.
All right.
Yes, Mr. Biswas, item 21. Mr. Prashar, we grant an interim. There's a scuffle between two sides. There are two FIR. Heard Mr. S.C. Biswas, counsel for the petitioner, and Mr. K.K. Parashar, learned APP for the state. Petitioners for apprehending arrest in connection with Tejpur PS case number so and so, page 1, here is bail under 438. That the case diary will be produced on the next date of listing. Next, the learned counsel for the petitioners has prayed for interim bail, which is opposed by the learned APP on the ground that the two sides were involved in a quarrel, and there is an allegation that the fingers of the left hand of the informant was cut. And some of rupees 4,700 was snatched from his pocket. Next paragraph. So just a case diary of two cases. One is Tejpur PS case number 668 of 2023, and what is the other?
639. 639.
639 of 2023. Considering that both sides were involved in a quarrel, relating to cutting of bamboo from the bamboo grove. The court is inclined to grant interim period bail to the petitioners, namely so and so. 40,000 with one surety of like amount. 7 days, they will lapse on the 8th day. List on when?
22nd of
Case diary on 22/11. Case diary or scan copy thereof.
Item 22.
22. You've been married. Not in bill then. Mr. S. Alam, counsel for the petitioner. Petitioners. And Mr. K. K. Parashar and AP for the state. Apprehending arrest in connection with Tejpur PS case number so and so. Page 1. TRS bail under 438 CRPC. Next one. Let the case diary be produced on the next date of listing. Next paragraph. The learned counsel for the petitioners have paid for interim bail, which is opposed by the learned APP on the ground that a girl has been kidnapped. Victim girl has been kidnapped. Next paragraph. On consideration of the marriage certificate, which is annexed as annexed 2 to this application, indicating that the victim girl and the petition number 1 was married on when on 17/10/2023. Court is inclined to grant annexure 2 and 3. The court is inclined to grant interim PRS bail to the petitioners, namely so and so. It's 40,000 each with one surety of like amount. Appear within 7 days, for which the interim bail will lapse on the 8th day. Case diary on
22nd.
10 days. Okay, make it 10 days.
22nd of
22/11.
Time being item 13.
Yes.
I spoke to the OC, Silchar. He said that 41A notice he has prepared. He has called the father as well as the party concerned to come to the police station. They have not come. He has no intention to arrest. But
Then
then
we
he
grant an
has
interim.
gone to their home. He
I grant an interim
said,
then.
I have no intention.
I'll grant an interim then.
Not.
Okay. Mr. J. I. Varmiya, counsel for the petitioner, and Ms. S. Jahan, learned AVP for the state. Next paragraph. Apprehending arrest in connection with Silchar PS case number so and so, page 1, PRS bail under 438 CRPC. Next paragraph. That the case diary be produced on so and so. Next paragraph. The learned counsel for the petitioner has paid for PRS bail, which is opposed by the learned APP. Considering that the petitioner is apprehending arrest in a matrimonial complaint made before the police, the court is inclined to grant interim bail to the petitioner by providing that in the event of his arrest, it's 40,000 with one surety of like amount. Appear before the IO within 7 days, following which interim protection will lapse in the 8th day. Case diary on
20th of November,
case diary or scan copy thereof. 20 20.
20.
Okay,
20th of
cabinet.
10 days.
Okay.
Okay, make it 10 days.
They should go and appear. There is nothing.
He may not be here.
Not. He stays in Bangalore.
7 days, 5 days.
Just now. You can't take it. You won't change the date. You know why? You know why? You must also know why I'm not granting you time. Because on 18th, he was here in Guwahati swearing an affidavit. So he can't be in, if you can come in, fly in for the day, sign and go back on the same day, he can again come back.
And let it be on 23rd. See,
23, okay.
Item
Mr.
20
Barbuya, I can't help it. I come from the civil side. So first thing is that
it's already-
yes, 23.
It's like, input from anywhere.
You're for the government.
Yes.
What do you say about this?
And first of all, we have some objection in this transport with one, and he has any, but he has failed to show any documents. Because as per Transportation Act, he has to produce the permit. Transportation permit, he has to procure it from the authority. But it is not, I have not find anything here. Needs to be.
So you give him a list of what are the documents required. According to that,
Let him apply, whatever. Required.
you ask before them what documents are required. And you, according to the documents, if you are complying with your, I'll issue a notice right now.
Yes.
I'll issue a notice. In the meantime, you apply before them for documents required and apply for those documents.
He can fulfill the order.
Yes.
Yes.
Definitely. No, you see, you see, otherwise, Mr. Bora is right. You see, you must be carrying it with a valid document, and they would have restrained you. Then I can understand. It affects your fundamental right, but that allegation is not here. You get my point? Because had you been restrained from traveling with a valid permit, then I can understand your fundamental rights are violated. But right now you have not done a transportation, so you have come on apprehension. Ideally, it's not a fit case to issue a notice. It's premature. But since you have come, you have a business we are entertaining. I heard Mr. M.K. Bora, counsel for the petitioner. And there are a few things today is a vacation court. I'm I'm not taking these things very seriously. You go through a constitution bench judgment of barium barium chemicals. A company does not have a fundamental right. There is not one judgment. There are more than one judgments of the Supreme Court saying that a company does not have a fundamental right to do business. Therefore, when we were young entrants, first thing which was told to us is that along with the company, a private individual must be there as a party. It is, and my young days, that was the first fundamental thing I was told. Therefore, company does not have a fundamental right. In today's vacation, we are overlooking these things. Correct. By filing this writ petition in Article 226 of the Constitution of India, the petitioner, who is a petitioner company, who is in the business of producing and trading in milk and milk products. Is seeking a direction upon the respondent authorities for allowing unhindered transportation of milch, MILCH, animals from outside Assam. Stop. Next, Mr. R.K. Bora, Standing Counsel for the You're a government advocate appearing for respondent. All the respondents then,
Except five, this is a BTC.
acha, for respondent numbers 1 to 4 and 7 and 8. Submits that prima facie appears to him that the writ petition is premature because the petitioner has not been able to show that he was transporting, that the petitioner company was transporting cattle and he was prevented from doing so despite having valid documents. Next para. Be that as it may, issue notice returnable in give a fixed date after 4 weeks. The requisite extra copies of the writ petition be served on the Ranat Standing Council for the Ranat Government Advocate, as well as the Ranat Standing Council for the respondent number 5. In course of the day. Stop. It will be also permissible to the Learned Counsel for the petitioner to provide requisite soft copies instead. Next paragraph. In view of the nature of prayer made in this writ petition, the court is inclined to provide that the petitioner has liberty to apply before the whom? Director Dairy Development.
Yes.
4.
As per section 7. For the appropriate authority, this will come.
No, but who? There are so many respondents here. I think Director Dairy Development will know. He will know before the Director Dairy Development Assam within bracket respondent number 4 for a list of documents based on which the petitioner can transport cattle. And it is provided that on such application being received by the respondent number 4, he will provide the petitioner company with a list of documents which are required for carrying public transporting cattle. Next paragraph. Needless to say that in the event the petitioner is transporting cattle, complying with the requisite documents, the authorities shall permit transportation of cattle from outside the state of Assam to the establishment of the petitioner. At village South Kajalgaon. And the PH Dhaligaon, district Chirang, within bracket BDC Assam. List on
412.
412.
4 of December.
24.
Item 24. Apply.
Right.
Is your lordship, lordship.
Will issue a notice here. In the pendency shall not be a bar, and I'll transmit the matter to.
Yes, yes, yes.
In the meantime, it will not be a bar for you to consider his application, give family pension if she is entitled to.
We have already given our this thing. Your lordship will kindly look up 23 months. There we have clearly stated that claim for drawing family pension being wife of deceased pensioner at this belated stage is not acceptable. So this will be the position. I think it is
Why?
decided.
Because the
No.
petitioner got married after retirement, lordship.
No, you see, if somebody is entitled to pension, let us say he's a government servant. Family pension is out of,
Normally, entitled.
no, what I'm trying to say is that if a government servant is entitled to, his legatives are entitled to family pension, it is because of his labor, correct? It becomes a property. Can you deny a citizen property just because he or she is late in applying?
So, my lord, that is why, my lord, I am saying, my lord, the court may have to, my lord,
Oh, no, we are now giving you a direction. If he's otherwise
instead
found
of, my lord,
entitled to,
let her not go for this parallel district. Let me get the instructions, my lord, or your lordship may keep this matter here also, because the family is from Tinsukia, Assam.
no, but the pension matters will be appropriate there only, not here.
That your lordship, my lord, it will offend your lordship. Your lordship, it's not that necessary that.
No, we'll not take away jurisdiction. Let it be there, but we'll say that if she's found entitled, you can process and pay. That shall not be a bar.
Her husband was receiving, and the main thing is that. he
No, we are
got
permitting
married
it.
after
Husband
his
has
retirement,
gone
lordship.
on PRS.
Yes,
Huh?
lordship,
Husband
and
has gone on PRS.
by
He
page
married
16.
4 years after
Yes.
his retirement.
Yes, lord.
No, if she's otherwise found, and if she's not entitled to, you give a letter, you're not entitled to.
That is what is stated, my
Lordship,
lord.
they
Huh.
have at belated
And
stage.
page 23. my lord.
Where, page 23.
Middle paragraph, my lord.
Yes, yes,
Page
please.
23, lordship.
Middle paragraph. He is not director of audit and pension.
Because at that time he was not married, lordship, and he duly intimated in 1999, lordship. If you're.
No, but then then Mr. Goswami is right. You see, the High Court in exercise of 226 will not confer upon you a status.
Lordship, if you kindly peruse page 16, lordship.
16.
Yes, one. Where there is a letter, lordship, after getting married, he has duly intimated, lordship, to the treasury officer, Ubesia District, Dalu. That's
No,
why
no.
that-
Treasury officer will not be, is not an authorized person to receive that and process it.
Because at that time, lordship, as a nominee lordship, he has communicated, because he was receiving pension
no.
at that time.
It will be, you see, these things have to be processed by the director of pension.
Director of Pension and Audit, lordship.
Is a treasury officer is no one to entertain this application.
But I have also prayed before the Director of Pension and Audit, lordship, where there is a reference of this, lordship, in page 8, annexer 8, lordship, page 23, where lordship was just now perusing, lordship. While referring to a representation number nil dated 7/12/2015 regarding sanction of family pension by the pensioner. This is their lordship. She prayed. He prayed, and now without getting these things, lordship, because they are almost in the verge of starvation, lordship. The daughter of the petitioner, she has to leave her study, lordship. And these things are there. And last page, lordship, page 33, where the executive engineer on behalf of the superintending engineer has written to the executive engineer electrical to look into this and take necessary action, lordship. They have not acted upon these things, lordship. Last page, page 33.
This is because, my lord, representation was made to all these authorities, so superintendent has directed the executive authority under whom the meter reader was working. My lord, the bank of my friend, my lord. So this is not a.
Where is the marriage certificate?
Marriage certificate is not there, lordship, but I have this, because they were in the village, lordship. I have stated the legal heir certificate, lordship.
Oh, this won't
Page
do.
number 22, annexer 7.
This won't do.
Next of kin, lordship.
This won't do because marital status,
Lordship.
High Court in exercise of 226 cannot grant.
Let me give them the instructions.
You get instructions, it is better. You see, why I'm saying so, Ms. Bhattacharjee,
Lordship.
is that under the Evidence Act,
Yes,
a
lordship.
marital status
Lordship.
becomes, declaration becomes a order in rem. And that can't be passed without hearing the what do you call the legal representatives of the of your deceased husband, marital status can't be granted. You see, I'm not questioning you. I'm not doubting you, but please try to understand the legal aspect. Somebody is coming to us and saying that please declare me as a wife and have me family pension. So that is a declaration of right. I must acknowledge you as a wife to make you entitled to pension. Can a High Court in original jurisdiction get original jurisdiction under 226 to give that declaration?
This is different, Lordship, because regarding declaration, Lordship, this is a separate.
So
forum.
unless you see, unless it is there under 42 or 43, I forget, of the Evidence Act, the presumption of a legal marriage, that must be there. The High Court would be last. Let me remind myself of the provision.
Regarding dependent also, Lordship, he has communicated in his lifetime, Lordship. This is also there in exact.
Yes, the section 50 opinion on relationship and relevant. When the court has to form an opinion as to the relationship of one person with another, the opinion expressed by conduct as to the existence of such relationship or any person who is a member of the family or otherwise has a special means of knowledge of the subject is a relevant fact. Therefore, I said that before I give a declaration, the family members of the husband must be heard. Otherwise, under section 50, we can't do it. Just check this provision. I'm not doubting you for a moment, but it is only the legal aspect I'm questioning.
Yes, Lord. But otherwise, Lordship, there are Lordship, maybe documents, Lordship, because the birth certificate of the daughter will also be very much be there. Where the name of the-
This opinion
yes.
in 226 for the first time as an original court having
Yes,
original jurisdiction. There is, but I'm issuing a notice. You get information. But I'll be transmitting this to Itanagar bench. Ms. M. Bhattacharjee, learned counsel for the petitioner, as well as Mr. B.D. Goswami, learned additional advocate general of the state of Arunachal Pradesh, assisted by Mr. A. Chandran, counsel for the government advocate, appearing for the respondents. Next paragraph. The filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities to grant family pension to the petitioner. To stop. Issue notice returnable on after 4 weeks. Give a date.
4th of December.
4/12. Convenient for you? You choose a date when you can go there.
Can it be on 8, Lordship?
8/12/2023. Next, the pendency of the writ petition shall not be a bar for the executive engineer, electrical department, along West Siang district, to take a call on the prayer made by the petitioner for family pension. Next para, as this matter relates to the Itanagar permanent bench, comma, let this record be transmitted to the Itanagar permanent bench. So, so that it can be listed before the said bench on the date fixed. Next para, list before the Itanagar permanent bench on 8/12/2023.
If you apply.
দুটা বিশেষ করতে
There are two unlisted matters.
এটা এসেছে
Oh, acha. So one unlisted matter, Rahul Amin.
production list item 1
In this matter, in earlier order 19/10/2023, Lordship is pleased to fix the date of
8/11.
2023.
Case date is not come.
Case the diary from received Lordship.
But why is this mention was made?
Lordship.
None appears on call for the petitioner. First of all, the matter has been listed on a mention memo being on a mention being made. First of all, on a perusal of the previous order dated 19/10/2023, comma, it appears that the matter has been listed, has been ordered to be listed on 8/11/2023. Full stop. Next, the learned APP submits Mr.
K. Bush, sir, Lordship.
K. Busher.
Lordship.
Learned APP submits that the case diary has not been received as the matter is fixed on 8/11/2023. So accordingly list the matter on 8/11/2023 as ordered earlier. Other bail application,
production list item 2 with item 25 of daily list
Mr. Kamar, your matter.
In this case, my lord, here is the sentence, my lord, that it is under.
I have seen that. I'll give you a
Yes,
bail,
my lord.
but it will be a fresh bail because it is after conviction.
Already I have one on face, but if your lordship will kindly look to my IA, my lord. I can show it, my lord. While I was on bail, my lord, I was again allowed to go on face. So lordship will kindly see IA, page 14, my lord.
14.
Originally during trial, I was on bail, then when I was convicted.
This is a fresh order of bail.
Yes, sir. I'll read for your lordship, my lord. Case is put up, accused convict has filed a petition, bearing such has submitted that he intends to prepare an appeal against the judgment of the peruse the petition heard. Accused, Otul Bora has been convicted and
Okay.
sentenced for
Okay,
3
okay.
years
It's a fresh bill. Okay, okay.
to go on principle, which I have done.
For Mr. Z. Kamar, Senior Counsel, assisted by Mr. B. Talukdar, Counsel for the, Counsel for the appellant. Next para. This will be an appeal, huh?
Appeal is to be admitted to them.
Again, page 1. This is by this appeal under section 27 of the Prevention of Corruption Act, 1988, read with section 374 CRPC, the appellant has challenged the judgment and order of conviction dated 5/9/2023, passed by the learned Special Judge Assam in special case number 23 of 2018, by which the appellant was convicted under section 12 of the Prevention of Corruption Act, and he was sentenced to undergo rigorous imprisonment for a period of 3 years and to pay a fine of rupees 5,000 with default stipulation. Next, the appeal is admitted for hearing. Let the records be called for. List on so and so. Just also write, K. Parashar, repeat for the state. No, IA, right, by,
I 106.
by filing this application under section 389 within bracket 2 CRPC, comma, the applicant, who is the appellant in the connected appeal, has prayed for suspension of sentence and oblique to allow him on previous bail. Next para. The connected appeal has been filed, same copy here. So. Next para. The learned senior counsel for the applicant has referred to order dated 5/9/2023, passed by the learned special judge Assam in special case number 23 of 2018, by which the applicant was allowed to go on fresh bail of rupees 25,000 with a surety of like amount for the appeal period till 6/11/2023. Full stop. Next, notwithstanding that the prayer for suspension of sentence, oblique bail is opposed by the learned APP, but considering that the applicant has been sentenced for 3 years, the court is inclined to allow the petitioner, applicant, namely so-and-so, to remain on previous bail in terms of order dated 5/9/2023, passed by the learned special judge Assam in special case number 23 of 2018. Next para. This application stands allowed and disposed of. We are disposing of this matter. Yes,
I heard that you were setting up rules.
if some matters are there,
So my lord, actually, while I was coming, there was a small accident. And I was struck down there. So I could not come at time I apologize for that. I have a vision while for the lordship. So I regarding eviction. The threat of eviction.
okay, move it, we'll take it up at 2.
Alright.
Yes, eviction will have,
You are-
will
you
have a
are-
priority. We'll take it up.
Yes.
Eviction bail for priority, right?
Huh?
Yes.
Eviction bail
Actually,
for this purpose.
they were permissive possessors in 2000.
It's okay, we'll take it up. Don't worry. Because unless I have a very bad habit. Unless I look at the file, I won't remember anything.
But your lordship has come fully prepared.
Huh?
Today your lordship usually comes also, but today I have seen pilot the lordship is fully prepared.
Oh, I do my homework and come. You look at this.
We talk-
You look at this.
We were talking like that. my lord.
I commented on him on
The-
one thing, my lord, which our senior used to say, it is book khulile Gorbosini power. So we are saying the judge is also knowing before the lawyer is saying. So all the preparations are there.
Alright, my lord.
Wonderful.
No, that the habit
I
of
otherwise never-
that habit of what you call making notes
Absolutely.
did not go. I'm
That's a
still
good
carrying
thing.
that.
To make notes, my lord, preparation of notes is very important.
And the backside, I used reused paper. I used recycled paper. In the backside,
No, backside already.
is already used. So I used recycled paper.
That's true,
But
my lord.
Mr. What you call?
Wastage of paper, my lord.
No, I was saying Mr. Borgo, Mr. Purago, that I could not grow. I still have to make notes too. Unless I have a cheat, I can't pass my exams.
I was your lordship has kept this here. That is nice.
I'm trying to look old now.
We are saying some other style, like mature jazz is good.
No, I'm trying to have a old look.
It suits.
Huh?
Because I was.
He says, my lord, that it is suiting your.
I don't know, it doesn't look good,
Yes, yes.
but I had that, what you call, very fascination to have it. So I'm trying to keep it for some time now.
What changes it is always good.
Can I request both of you to come inside and have a cup of tea with me
You might have been there. Oh, nice.
for the government who's there? Yes, you can also join in so that both can join in. So you can't accuse that I'm only. Okay, we'll have a cup of tea because
One. Sir,
Huh?
item 25 you admitted-
item 25.
admitted by the Goyal, sir.
Huh.
He admitted for hearing in timely means, 4 weeks back. Item 25 is commerce.
Mr. Kamar, what happened to item 25? I forgot. 25?
Admitted for hearing, admitted for hearing.
No, this is bail application. Oh, acha. That is admitted for hearing. Time हो रहेगा. After 4 weeks, call for the records. We are not giving a fixed date here.
Item 10 timely.
Item 10? Oh, this, somebody made a mention after some time. You are there?
I made a mention for unlisted matter method. The matter is whether.
No, item 10. Unless some matter had come. We already passed orders. What is that order? No, we have fixed a date. You see, the trial court may have given it to you. You can withdraw this matter, you can move the trial court. But once we have fixed a date, today the case diary is not available. I can't grant you bail merely because the trial court has granted you. Correct? You have a choice. You want to exercise that choice to withdraw this application and move the trial court? You can do it. Because here we have called for a case diary on a fixed date. We can't. Huh?
On 8th March.
On 8th. Okay. Your name?
El Islam. El Islam.
El Islam
El.
for the petitioner. N.
L.
L. Okay. You record your presence because he should be absent. Kuntu. Okay. Arnie? Okay. Diary on? 8/11/2023. Okay.
Production list item 3. PA 4014.
439.
Just a minute. Where is the FIR?
Fire is that page, annexure 1, page number 11. The translated copy is at page number 12. It starts at page number 12. The FIR was the student superintendent of police Hojai, my lord. The complainant, my lord, the informant is the president. He was the president of Lasit
Get the case diary here because it's swindling of government funds.
My lord, I will satisfy your lordship. There are some points I will make the submission on, my lord.
Yes.
Because my lord, if your lordship, there is this page number 17, that is annexure 3, my lord. The entire FIR is an act of vengeance against me, my lord. It is a revenge taken against me because, my lord, this letter will make it very clear. This letter was issued on the date when the FIR was lodged, my lord. It is 21/8/2023, my lord. This letter was from the Block Elementary Education Officer Lonka to the District Elementary Education Officer Nagaon. The subject here, my lord, regarding change of president of Lasit Kothar Julalia ME Madrasa and reformation of new school managing committee. My lord, if I may read the contents of this letter. My lord. With reference to the subjects cited above, I have the honor to forward herewith an original copy of the petition received from the headmaster cum member secretary of the Lasit Pathar Julalia Nami Madrasa regarding change of president from for smooth running and midday meal service and other financial related matter. The terms of school managing
You
committee.
see, that may be there, but in the FIR, it shows that there are specific instances of check and the money swindled.
I understand, my lord, but during my.
No, that may be there. You see, there may be some enmity between two of you. But here the president of the managing committee has specific,
He is no longer, my lord,
no, maybe he is not, but the specific instance of a check contains forgery of the signature and withdrawal of money. We'll have to have a case diary, not without case diary.
Post interest of conditions, my lord, I will.
You see, after that, we don't have power to recall, once we grant bail in under 439. No, not without case diary. When it's a case of embezzlement of school funds. 811,
Lordship, it is from Lanka PS, Lordship, it.
Lanka is,
May it be, Lordship, 14 or 13, Lordship.
we're not giving an interim, so therefore,
Yes.
get the case diary earlier. Scan copy you will also do.
Okay, Lordship. Can it be
Uh,
on 10, Lordship, 10, my lord?
10th, okay.
Yes.
Case diary or scan copy thereof on 10/11/2023. Get us a scan copy also, that will do.
Yes.
Production is item 4.
Yes, Mr. Brother, your matter.
They are all indigenous people. They are all permissive possessors. The deputy commissioner in the year 2020, the tripartite agreement has let them stay there. They are all small shopkeepers. Being e-store and nice what you call hotels, etc. And before that, my lord, at in the year 1996, some land has been given by the petitioners' headquarters for construction of the civil hospital there, and they did not take any compensation for that. But government has given them alternative land behind the plot that has been acquired by government, with the condition that they will be allowed to do some small business there, and third gate, fourth gate employment, they will be settled there. In the meantime, my lord, we were there in the tripartite agreement. Your lordship will find page 19, that there. So page para 2, Chittagong district administrator would sincerely consider to embark a plot of land on the north of the 80 road in front of the civil hospital for establishing a market complex where all the 54%, now it is 9, some of them has been already accommodated. Then in 3, the income, this is the income of that complex will be used by the hospital. Number 4, until the proposed market complex is completed and the 24 signatories are settled in as tenant, all the 54 persons are allowed to accommodate their business on both sides of the approach road leading to the hospital from 80 road outside the hospital campus and both the eastern and western side of the boundary. So they have been allowed to continue there, my lord. Then, my lord, your lordship, we had to come before your lordship earlier also, because there was a brief. Your lordship will go to page 48. The same persons, they had come before the 46 is the my lord page 30. So 9 petitioners here have approached the court jointly by filing the petition so that they might be evicted from so under the occupation without following due process of law. According to the petitioners, they are running petty shops, various kinds of situated in Shivsagar Hospital, Joysagar, since past several years for earning their livelihood. The petitioner have also applied for settlement, this is important, settlement allotment of land under Mission Bosundara 2.0 and their application pending consideration before the appropriate authorities. Nothing, notwithstanding the thing, the respondent number 2, 3 are threatening to evict them. Then, my lord, last portion, after hearing the submission made at the bar, taking note of the facts and circumstances of the case in entirety, this petition is being disposed at the stage of motion hearing, provided that possessions of the petitioner over the Sarkari land under their occupation shall not be disturbed without serving prior notice on them as per law and according to the order of 21/7/2000. The request made by the petitioners for allotment under Mission Bosundara 2.0 and also allotment of alternative shop at the market complex also constructed by the distributor. We also appropriately examine before an ethics drive is carried out without giving carried out against them before. So then, my lord, before that, in the year 2017 also the same thing has been done by the circle officer at page 49, my lord. Here also the interest of the petitioners were protected. The petitioner shall serve as circle so and so. Second paragraph, my lord. In the meantime, this
Which page?
my lord?
Which page?
49.
49.
49,
Yes.
second paragraph. Second paragraph. The petitioner shall serve exactly so and so. On behalf of the respondents, let this matter be listed on none. In the meantime, the respondents are restrained from giving effect to annexure 4. The writ petition, which is a notice dated Iman issued by the circle officer Amguri Circle till the next returnable date. So that petition, my lord, at page 52, your lordship will find interim order passed earlier by the court on 11/1/17 shall continue until further order. So we are on the basis of this, we are in the possession matter. Now,
No,
my
but
lord,
you see, from what you are showing, we find that the deputy commissioner has given you space on the road
no,
to have your business.
yes, we are also we are on the road. Your
No.
lordship can.
No, you see, this annexure 9. Now you are inside the hospital.
No, that is incorrect. Your lordship may direct to have an inquiry on that. They are in the original place, and if anybody inside the hospital bar, we are not there. We are
On the road.
on the approach road. And moreover, my lord, your lordship, when these two judgments have been gone from the cycle, so deputy commissioner was a party here in this annexure 9. He did not sign it because he knows the whole process is under settlement process is under consideration. So it has been sent by the superintendent come members. So
Because you see, that is right. Under the Public Premises Eviction Act, it is by the occupier of the property who has to give that.
You will inform to the deputy commissioner, deputy state officer. He will file the notice, not he.
Okay,
Because
yes.
More than anything else, this is the health department has not been, I think, served a copy. This is superintendent of the Shivsagar Civil Hospital.
which are now, that's why we have.
No, it's health department. Has not been served. More than anything else, no, lordship, they have their standing council, revenue also have the standing council. The name of the revenue has been reflected here. The health department has not been reflected here.
Health department as such is not included, my lord, because only the superintendent of particular hospital he has done. Our
He'll be
intention is
represented by
that
the health department.
he is managing the affairs of the hospital, not the, not the land. Land is of the government, managed by the deputy commissioner and revenue department. Only that the.
No, but he's right. If the superintendent is a party, then health department has to be a party.
No, we will make a party. Immediately. And I will.
But
find it.
we'll make it clear that if there's any space inside the hospital, that can be
Yes,
removed.
yes.
Only
But
that,
we will specify that they are in the approach road, both sides of the approach.
no, we'll see that this, if it is covered by this agreement, space is covered by this agreement.
Yes.
That order at page 19,
90.
except that.
Huh.
If it is in the hospital, they can be removed.
No, by taking routes to the provisions.
No, if it is within the campus, then that's not required.
Third notice by the state officer, this point.
No, those procedures.
Procedure, I
No,
leave it to
you see, no, Mr. Buragwai, you see, your submission is that you are not inside.
Yeah.
So therefore, what happens inside is outside your scope.
Yes. No, that is also, my lord, when one is from 2000, we are staying here.
No, that's okay, but
Notice is,
no, but you are saying that you are outside. You are within this.
no, yes, my lord. I have.
Huh.
I-
Within you are within this page 19. You are doing as per page 19.
My lord, that I agree.
Huh. So therefore, if anybody is inside, you are not holding brief for them.
And in the petition also we have said that we
No,
are.
it's okay. Once you say we respect it, we don't want a proof of your statement.
Yes.
But the fact is that you are not holding brief for people who are inside.
No,
And in fact, in para 4 itself, it is very clear, Your Lordship. Until the proposed market complex is completed and the 54 signatories are settled as tenants, all the 54 persons are allowed to accommodate their business on both sides of the approach road leading to the hospital from the 80 road, outside the hospital campus.
Outside the hospital. So it's okay.
that is what we want.
Heard Mr. A.C. Buragwai, Leonard, Senior Counsel, assisted by Mr. R. Singh, Counsel for the petitioners, and also Mr.
CS Hazarika. for
C.S. Hazarika, Leonard Government Advocate, appearing for respondent number
2 and 3, Your Lordship.
2 and 3. Next, at the outset, the learned government advocate has submitted that the respondent that this matter has been taken up as an unlisted matter, and therefore, as the learned standing counsel for the revenue department as well as the health department had no notice of this unlisted matter, the standing counsel for the said department are not available. Full stop. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioners have assailed the impugned notice dated 10/10/2023 issued by the superintendent cum member secretary, Hospital Management Society, Sivsagar Civil Hospital, within bracket annexure 9. Issue notice returnable on so and so. Give a fixed date after 4 weeks.
4 weeks.
Returnable on so and so. Requisite extra copies of the writ petition be served on the learned government advocate as well as to the learned departmental counsel for revenue department and the health department within 2 days. Stop. It would be permissible to the learned counsel for the petitioners to serve soft copies of the writ petition to the learned standing counsel. Next para, the learned senior counsel for the petitioners has prayed for an interim relief on the ground that that by virtue of an order number capital SVRS full stop 47/2000 dated 21/7/2000 by the Deputy Commissioner Sivsagar, 54 petty shopkeepers, which includes the petitioners, were assured of space in a market complex to be established in front of the civil hospital, Sivsagar, for doing individual business on payment of rent. And it was further provided that until the proposed market is completed and all the 54 signatories are settled as tenants, they would be allowed to accommodate their business on both sides of the approach road leading to the hospital from the 80 road, outside the hospital complex, and on both the eastern and western side of the southern boundary of the 80 road, which is more fully described in the said order. So accordingly, it is submitted that as earlier in point of time, the petitioners were sought to be evicted from the respective business premises, the petitioners had approached this court by filing WPC 4417 of 2023, and this court by order dated 4/8/2023, disposed of the writ petition at the motion stage by providing that the possession of the petitioners over the inverted commas, Sarkari rent, inverted comma closed, under their occupation shall not be disturbed without serving prior written notice upon them as per law and in accordance with the order dated 21/7/2000. Full stop. This you will find at page 48-49. Full stop. It is further submitted that once again their position was sought to be disturbed, and the petitioners had approached this court by filing WPC 213 of 2017, which is pending for disposal before this court. Next paragraph, it is further submitted that the Deputy Commissioners, Sivsagar were parties in both the aforesaid writ petitions. And therefore, this time, the Superintendent cum Member Secretary, Hospital Management Society, Sivsagar Civil Hospital, within bracket, respondent number 4, has now issued a notice with the petitioners directing the petitioners to vacate their unauthorized occupancy inside the hospital campus. So it is submitted that the respondent number 4 may not be the competent authority to evict the petitioners under the provisions of public premises, within bracket unauthorized occupants, bracket close act, 1971, right?
Act is 1972. 72.
Hmm?
Act is 71.
The name is correct. Public premises within bracket unauthorized occupancy act. And it is submitted that the deputy commissioner is the competent authority under this said act. Next paragraph. The prayer for interim relief is opposed by the learned government advocate on the ground that as per order dated 21/7/2000, space outside the hospital campus was earmarked for accommodating the 54 persons to do their business. However, it is submitted that from the impugn order dated 10/10/2023, it appears that some persons named therein have unauthorizedly occupied space inside the hospital premises. So accordingly, it is submitted that the illegal encroachment over the hospital premises would be prejudicial to the public interest, and therefore is an objection against the prayer for interim relief. Next paragraph. The learned senior counsel for the petitioners have submitted that as per his instructions, the petitioners are occupying the allotted space in terms of the order dated 21/7/2000, which is outside the hospital premises, but within the approach road, in terms of the said order passed by the Deputy Commissioner Sivsagar. Next paragraph. Considering the said submissions and also taking note of the order dated 4/8/2023 passed by this court in WPC 4417 of 2023, the respondent authorities are restrained from evicting the petitioners or from demolishing their shops, which are located within the area described in paragraph 4 of the order number capital SVRS full stop 47/2000 dated 21/7/2000 passed by the Deputy Commissioner Sivsagar. This number you will get at page 19. Full stop. So it is clarified that this order shall be confined to the space mentioned in paragraph 4 of the said order dated 21/7/2000, and this order shall not prevent the respondent authorities from evicting any authorized occupants within the Sivsagar Civil Hospital campus. I.e., outside the scope of paragraph 4 of order dated 21/7/2000. So next paragraph, the petitioners are permitted to produce a certified copy of this order before the respondent number 4 to bring the order to the notice of the said authority. List.
Finally, allowed to 8, that's number 5.
Achha, no, you'll have to do it in this section. Next para. Just before the next date, list on so and so, we'll just go that. On the prayer made by learned senior counsel for the petitioners, his instructing counsel is permitted to implead the health department as respondent number 5, which shall be done in the in the concerned section.
It's not 4/12/23.
Mr. Dekha, why you are here? No, but you must be elsewhere. You have some responsibilities to shoulder now. Correct? Huh? Oh,
If I can say one thing, you're also saying within the federal campus, they may be addicted. Outside that, annexer, that page 19. So my prayer is that after following due process of law.
no, that I won't say anything because you are not holding their brief.
Yes.
So that would be, if your stand is that you are within that, then that becomes something very, what do you call it?
Okay.
Anything more?
Obligement.